morning. Please be seated. This is the time set for oral argument in the matter of Egizii versus Egizii. Our civil number 17-0199. Each side will have 20 minutes within which to present their arguments here this morning. We have read the briefs, gone through the record, we've conferenced the case, so we're familiar with underlying facts and issues raised by the parties. So please keep that in mind as you make your arguments here this morning. Appellant will have, can reserve some portion of their 20 minutes for rebuttal, but it's up to you to keep track of that time. We're recording the proceedings, both audio and video. The video will be available on YouTube in a matter of days after the argument is completed. We would appreciate, however, that as you approach the podium, that you identify yourself and your clients for us and for that audio and video record. And with that, appellant may proceed.
Thank you. May it please the court, my name is Jeff Proper. I represent the defendant appellant David Egizii, who is in the courtroom behind me. The issues in this case are rather narrow and rather well defined. I won't bore the court with what it already knows in terms of the factual background. At some point, this partition action was filed, and not uncommonly, there are issues then related to what will be the division of the proceeds from the sale of the house between the plaintiff and the defendant. The defendant in this case provided essentially all of the funds necessary to not only acquire the Arroyo Verde residence, but also to do substantial improvements and to provide virtually all of the repair and maintenance that this house required from its acquisition in 1986 until essentially today, but certainly until 2014 when the parties separated residences. The issue that is presented primarily in this appeal deals with one of the mortgages that the appellant paid, and that is the Saguaro mortgage. When the property was acquired, it was acquired at a trustee sale, and at the time of the trustee sale, there was an existing first mortgage against the property in favor of Saguaro Savings. The mortgage that was the subject, I should say deed of trust, which was the subject of the trustee sale, was in second position. So that when the trustee sale occurred, and in accordance with ARS 33811E, the senior liens remained obligations against the property. From and after the date of the trustee sale, the defendant appellant paid all of the mortgage payments related to that underlying mortgage, some $212,455.03 to be, I believe, accurate. After the trial was completed, the trial court denied the defendant a right of contribution for his payments made on that mortgage. There were two other mortgages that were created against the property subsequent to its acquisition. There was one in favor of Metropolitan Bank, and then there was, after that, a HELOC that was placed against the property. Those are not an issue with respect to the appeal and the trial court's findings that, based on the defendant's testimony, that the Metropolitan mortgage was used to pay his bills and was sort of non-specific whether those were joint obligations or not, denied contribution. The problem is that the trial court lumped in its decision and in its subsequent under advisement rulings referred to these as just mortgages without saying which mortgage she was referring to. So we can only presume that she might have been referring to all three mortgages when she denied contribution to the defendant. By the way, so it's clear, I'll reserve 5 minutes for rebuttal. The problem with the trial court's ruling is that the Saguaro mortgage predated the acquisition of the property by the parties by some 9 years. The Saguaro mortgage, which a copy of which is part of Exhibit 102, admitted in evidence, reflects that it was an obligation created by the Follettas in 1977. So at the time of the acquisition of the property through the trustee sale process, that mortgage had already been created some 9 years earlier. The trial court's finding that the defendant should not receive contribution for that mortgage resulted from a couple of things that she said in her under advisement ruling. And that was essentially that the defendant testified that he purchased the property with his sole and separate funds. Well, that's very true. That, however, is part of the contribution that the defendant sought and part of what the trial judge gave him. Second, she said the defendant was adamant in his statements that the property was purchased by him as his sole and separate property, even though the trustee's deed reflected that it was taken by both the plaintiff and the defendant as joint tenants with right of survivorship. The problem with that is the court seems to want to essentially punish the defendant for taking a position that he believed that he solely owned the property, even though the plaintiff's name was on the deed. The court at the beginning of the trial asked whether or not the defendant was taking that position, and counsel advised the court that the only issues with respect to the defendant was the right of set-off and the right of contribution, that the deed said what it said and that they were not necessarily going to go beyond it, although there was testimony in the record as to what happened between the parties at the time the trustee sale happened in 1986. So the fact that the defendant believed, or the court stated that the defendant was adamant that this was his sole and separate property, is essentially irrelevant for the purposes of contribution, because a party may believe that they are the sole owner of a piece of property, notwithstanding how the title is reflected, and expend money to make mortgage payments and interest payment and taxes and insurance and repairs and improvements, and they may be wrong. They may be wrong. The problem is that the co-tenant who comes later and says, I want to partition the property and I want half the proceeds, is now inequitably receiving, or is asking to receive, the benefits from the fact that, in this case, the defendant made all of those payments. Whether he believed he was the sole owner or not, the plaintiff got the benefit of those payments and cannot escape responsibility for contribution because someone, including the defendant, claims that they should be deemed the sole owner of the property. So the court's finding in that regard is kind of irrelevant to the ultimate determination as to whether or not the defendant should receive contribution for all of those mortgage payments, some $212,000, for lots of repair and improvements, for property taxes.
Talk about repair and improvements, because you said there are two things. There's the mortgage and then there's the repair and improvements.
Right.
Can you address those specifically, and how do you base the claim that he's entitled to contribution, and how should that contribution be valued in your opinion?
Well, there's no bright line test. If you're just talking now about repair and improvements as opposed to the mortgage obligation, there's no real bright line test as to what constitutes repair and maintenance and improvements. In this case, the trial court found, based upon conflicting testimony between two appraisers, that the property has what's called a knockdown value, which means its only value is the dirt. In that case, the case law is pretty clear that there is no right of contribution for improvements that were made to the property. The case law, however, is pretty clear that repair and maintenance, which occurs over a period of years, which includes property taxes, which includes property insurance, and which includes the upkeep of the property, are compensable through contribution. So in this case, there was a lot of evidence and a bunch of exhibits that were offered and received in evidence where, in this case, the defendant, for his version, presented a bunch of invoices and canceled checks indicating the things that he paid. Replacement of a garage door that somebody backed into it, air conditioning units, and things like that.
And let's further parse that out. You've got property insurance, you've got taxes. Where do you get the idea that replacement of the garage door, where are you getting that that is treated the same, or is it treated differently than the improvement?
They're not treated differently. If you wanted to create a distinction, you can say if you don't pay the property taxes, you risk a tax lien foreclosure that would cause the loss of the property. However, if you don't pay the property insurance, all that happens is that you're uninsured. If you have a casualty loss, you don't get to recover from the non-existent insurance company. So the courts seem to lump these things together. They talk about mortgages on one hand, they talk about taxes and insurance and repairs and maintenance on the other hand. I don't think there's a question under the case law that both sides have cited that repair and maintenance is paid by one of two co-tenants is compensable. It's the definition of what constitutes an improvement.
In those cases where we're talking about repair and maintenance versus improvements, there wasn't a finding that it was knockdown value, was there?
Yes, the trial court, in fact.
No, in those cases that you're saying.
No, but the case law, though, is very clear that if the improvements, as distinguished from repair and maintenance, if the improvements do not add value to the property, you can't recover.
Well, and we only give them the value of, we don't reimburse them for what they paid, but only the improved value.
Correct.
Okay, well, in this case, you have a home that the trial court found was knockdown value, which is a factual determination.
Correct.
You live or die with that.
Correct.
And why would we give you repair and maintenance when the home itself is not worth anything?
Because the repair and maintenance is necessary for the parties to live in the home from 1986 until some day when this case is resolved or the house is in fact knocked down. So one relates to the party's use and enjoyment of the property. The other one, the improvements, relates to whether or not a contributing co-tenant who improves the property is entitled to the benefit of the increased value in the property as a result of those improvements. So they're very well defined.
Oh, wait a minute, because you just said the enjoyment, it goes to their enjoyment of the property. So you put an improvement on a piece of property that both co-tenants enjoy, but it doesn't add any value, then you don't get anything back when you sell the property. But if you would say, well, then that wasn't an improvement, that was just a repair, and then I do get some value back from it. And under your theory, not only do you get some value back, but you get half of that repair because it's a repair.
Correct, because I think you have to distinguish in this case, and the trial court did not do so. You have to distinguish between what are really repair and maintenance and what are really improvements, because improvements in this case don't benefit anybody. And so if my client, the appellant in this case, spent $100,000 doing improvements, then he gets nothing for that. It's just part of what he contributed that is lost because it didn't really add any value to the property. That's different than, for example, living in Phoenix, Arizona on July 15th and having your air conditioning unit go out and it needs to be fixed. Otherwise, you can't live in the house. And maybe that air conditioning unit needs to be replaced because it's worn out. Those are repairs. Those are maintenance that relate to the party's use of the property. You have to do those things in order to be able to live there. You don't have to plant a garden in order to be able to live in a house. You don't have to add a room addition on in order to be able to live in the house, but you do have to fix a broken water line, a broken sewer line, an air conditioning unit that goes out. Those are repair and maintenance that are compensable under, as I read it, every case that's been cited.
So your client's burden then was, in your view, was only to show that the repairs or maintenance were necessary, number one, and number two, the amounts expended were reasonable.
Yes.
Is that in the record?
The record reflects the introduction of many exhibits, and the defendant testified with respect to each one of those exhibits, now maybe not artfully, as to what constitutes in his mind improvements and what were repairs. And did he testify that the bill for the replacement of the roof or the fixing of the roof was a reasonable and necessary expense, and the amount expended was reasonable and necessary? With respect to some of them, yes. With respect to some of them, he just testified what they were for and what the amount was. And quite frankly, there was no challenge to that. There was no dispute in that part of the testimony as to what was expended and how much was expended. So I understand the repair and maintenance issue is a dicey one. The problem in this case is that the trial court simply said, well, I find that these are cost of living expenses, okay, that I'm going to deny both parties any right of contribution for any of those expenses, even though the amounts expended by each of the parties was grossly disproportionate. So I think in that case, the trial court was obligated to extract what was an improvement and what was a repair and maintenance, because it's clear when she talked about the plaintiff's expenses, okay, which were yard maintenance. I think in their brief they talked about that she bought fabric for the house, that she bought groceries and things like that. And the court seemed to say that's the same as replacing or fixing an air conditioning unit, fixing the roof, and things like that, which are clearly, you know, one is just an ordinary necessary living expense, and one is real repair that the structure and its component parts needs. And therefore, I think the trial court was just clearly wrong in lumping those two together, and they need to be broken out. And that's why I think that the trial court's ruling in that, saying it's inequity, is clearly erroneous.
So let me just make sure I understand that dollars expended on repair, there's no monetary value. Is the court supposed to get into a weighing of, you spent this much on this, you did this work, it's worth this much? Is that what you're asking us to do?
I'm not asking you to do that, because I don't think that's your job.
I agree, but it sounds like that's what the court did and said it's a wash.
Well, that's what the court said, but what the court washed was landscaping, house cleaning, groceries. If you take a look at what the trial court said against what are clearly repair and maintenance items. One is clearly not, and one clearly is. And I don't think the court, even using the loose term inequity, I don't think the court has the discretion to offset the kinds of expenses that the plaintiff wants to offset versus the kind of expenses that the defendant incurred for those component parts of the property. I think that's the difference. Do I need to go into anything further on the Saguaro mortgage issue, or has the court got it?
I think we understand your argument.
Great. All right. I've got 2 minutes and 21 seconds left, and I'm done.
Good morning, Your Honors. I'm James Viles, and I'm appearing for the plaintiff, Appellee, who's also present today. You know, in looking at this, what's at issue right now, and maybe I don't see this as being all that complicated. I think these are simple matters for you to determine. I think the main thing here is did the trial court abuse its discretion in doing what it felt was equitable with these parties in this particular situation under these facts. And both parties testified about their recollection of the facts. They provided, documentary evidence about it. Obviously, the defendant did much more than my client. I think one of the things that I would ask you to consider in doing your opinion is how diligent defendant was in keeping his records, and how diligent he was in showing all of the things that he believed he should get reimbursement for over this 30-year period, which it was a long period that they lived together and they raised children together in that house. And with regard to what both parties requested, the court did what it felt was fair under the circumstances and under the evidence presented to it, and neither party got everything they wanted, which is typical in litigation. For example,
Could I ask you a question?
Sure.
And let's focus for a minute on the Saguaro
sure.
mortgage. Do you agree that the Saguaro obligation predated the acquiring the property?
It appears it did. It appears there was a deed of trust in some other party's name in 1977, but we also don't. I mean, the evidence in this case doesn't show whether that continued to the date of the sale in 1988.
Well, I thought there wasn't a dispute that the appellant in this case paid the balance of the Saguaro mortgage.
No, that we don't concede that. No.
Well, I thought your client's testimony, as I read the record, is that only she may have paid a few payments.
Right, but I guess where it matters is, so they purchased this property at trustee's deed sale, and defendant comes up with $183,000 or so, he says. See, my client testified that she believed that money came from a different source.
Well, that's not the issue.
No, I know.
Let's get back to the
Right,
issue.
right.
Who paid the Saguaro? It was paid. At the time of sale, the Saguaro obligation is paid off.
I don't know. We don't know that. I don't think the evidence shows that. Defendant doesn't show that.
Is there any? I did not realize there was a dispute that it had been paid.
We didn't know whether it got paid or not. Our position is the defendant claims he paid
When
it.
she filed for a petition, what did she believe was outstanding on the property?
At the time they
filed for
purchased
a
it, that they
petition.
bought it outright. She had no idea that there was any encumbrances on it.
Then how did she make several payments on that mortgage if she didn't know there was an encumbrance?
No, I think if I don't have the record in front of me, but I think if she said that the mortgage payment she helped him pay may have been the Bank of America one that came later.
So then there's no dispute that to the extent the Saguaro mortgage was paid, it was paid by.
If it was paid, if it even existed at the time. See, that's the problem with defendant's evidence. He didn't show what encumbered the property at the time that it was purchased.
It's an exhibit.
Well, I didn't see that there was a deed of trust itself that existed that was payable at the time they bought the property. Yeah, it existed
Back and
before.
look at the exhibit. You believe it's going to be dated before or after purchase of the property?
Which exhibit? No, I'm sorry, and I don't mean to be.
For the Saguaro exhibit, for the mortgage, for the deed of trust on the Saguaro, from that.
Well,
we're
there's
calling
yeah,
Saguaro.
there's an exhibit that shows 1977
Prior to what?
Yeah,
The deed, okay.
that he claims encumbered the property at the time that they purchased the property. The problem is he doesn't show. I don't know. He didn't make, I think, a sufficient showing to the trial court that he paid that off. And there was another Bank of America mortgage, and then it was bought by several lenders, as I indicated in my brief. But he doesn't show he actually paid that mortgage. He doesn't actually.
Let me ask you this question.
Okay.
Let's assume, this is just a hypothetical. Let's assume that the record indicates that he paid it off. Would he be? It was a mortgage that was acquired prior, that was on the property prior to his purchase, and he paid it off. Would your client have to make contribution towards that in the sale of the property?
Possibly. I mean, I guess where I'm look, in hypothetical, yes. If he had proof to show it, yes. I think the issue for the trial court is he didn't have sufficient proof, or proof enough to show that it occurred.
Is that what Judge Brenovich said?
It doesn't say it in there specifically, no. And again, I think some of us are making some assumptions on what she may have been thinking and when she did the decision. But from our perspective, though, again, look, I guess my point is on the Metropolitan Deed of Trust. My client was part of that. She signed that, and he admitted that that wasn't for it had nothing to do with the home. It was to pay bills in his own name. I guess my criticism or my issue with defendant's presentation at the trial is he didn't specifically show he paid the Sahara loan off himself.
Okay. Bank of America took over the Sahara mortgage based on what we've got in the record. It says that they sent a letter dated March 2006 addressed to the prior owners, returning one of David's checks because the loan is now paid in full. And that's on your transcript, Exhibit 106, transcript page 197. So when you say there's no evidence, there was testimony, and it sounds like there may have been a letter that was admitted into evidence. Do you dispute that?
No, I have the exhibit in front of me right now. So it's several pages. So I don't dispute that.
So it does show that David was making mortgage payments to Bank of America, and that when the deed of release and reconveyance was filed, it would have been filed with the prior purchasers and both of the Egizii's name on it, correct?
It appears to show that.
So how does that not show that there was a mortgage, it was paid, and there's a certain amount of money that was paid? I'm not following why you're
Right.
taking issue with this.
Well, no, and I don't mean to waste a lot of time on it. Again, it appeared to me, and it doesn't say it in the decision, that perhaps the judge didn't feel like there was sufficient evidence to hold that mortgage, I guess, against my client, because perhaps there wasn't enough evidence to show that he actually made those payments. That the evidence itself wasn't sufficient for the trial court. That's maybe more the argument that I'm
Okay,
making.
I understand.
And I don't know. Look, I'm not in her head, and I don't know, why she made the decision particularly on that. But it seems to me that, well, certainly looking at the exhibit that you're referring to, the mortgage somehow was in his name only, or it wasn't. My client wasn't on that mortgage, so she certainly didn't know anything about that particular mortgage, she wasn't liable for it to be evaded herself. So.
Well, she may not have been, but it was on the property.
Right, no, I'm just saying that she wasn't on the mortgage itself. So, again, I guess what the argument here is that the court in equity did what it thought was fair under the circumstances, under the evidence that it had before it. And I think, as the judge found, that the mortgages were his responsibility, and they weren't my clients, and she had nothing to do with them. Certainly not the Metropolitan mortgage. So, and again, and Your Honor, you directed me away from it, but she had argued that the money used to purchase the property was from both of them. And again, the judge didn't find that credible. She found something else to be credible. And I'd say the same on the mortgages, that she had the ability to do what she did from an equity standpoint to decide, okay, on the mortgages, those are his responsibility.
Well, you can do in equity what is legally based on the evidence. And that's why I asked you the hypothetical.
Right.
If, in fact, we find that the evidence shows that the Saguaro mortgage was in place at the time of purchase and it's now paid off, she's obligated when the property is partitioned to reimburse him for the payments on that.
Okay. Well, then I would argue that, because I don't think that the evidence is all that clear that's before the court, especially as to what he actually paid and on what mortgage he paid, because at some point it becomes a Bank of America mortgage, and we don't know why. We don't know how it came to Bank of America, and Bank of America, he's paying on a Bank of America mortgage using funds from a business. A business paid those, not him personally. So we don't know, where the mortgage, did he borrow money against the property and pay it back for business purposes and pay it back with business money? There wasn't, I guess my point is there wasn't sufficient evidence on the record. Well, there was enough, the evidence on the record was to a point where the judge could make the decision that she made, that it wasn't sufficient to her from an equitable standpoint, that like I said in my brief, all the dots aren't connected between these things. There was a lot of information he could have provided to the court on those mortgages, and he didn't. And he was very diligent about keeping his other records. But, suddenly he doesn't have the Sahara mortgage itself, or to show why Sahara became B of A or where B of A even came from. Because he made payments on the B of A mortgage. And where did that come from? And he doesn't show where that came from. So, and with regard to the expenses and the things that the parties paid for and the court, as you mentioned, it looked as though it was a wash. I would agree with the court's argument, or at least the questioning along the lines of, if it's a knockdown property, what value was there? What I was thinking about that issue was, what value do you put on some air conditioning repair bill that you did in 1993, and you're litigating it in the 2014. Over time, well, how does the trial court put a value on something like that? I think it's impossible to do. Both parties presented evidence about doing similar things. So, I think that the court's decision on that was certainly not an abuse of discretion. It had the discretion to make the decision it did on those expenditures. So I don't know, unless we want to talk about the mortgages anymore. I don't
think there are any further questions,
Okay.
counsel. Thank
Okay.
you.
I buy his 7 minutes that he has.
I think we'll give you the 2 minutes and
I
19
think that's all I
seconds,
need.
Mr. Proper.
I want to close the loop on this mortgage issue. If you take a look at Exhibit 103, 103 is the deed of release and reconveyance on this property. 102 contains the Saguaro mortgage itself, is I think about the 4th page down into the exhibits. And if you compare those two exhibits, the deed of release and reconveyance tracks the docket and page number of the Saguaro mortgage. It tracks the date of the Saguaro mortgage, and it's signed by none other than Bank of America. And at the end, it says Bank of America N.A. successor by merger to BA Mortgage LLC as successor in interest to Nations Bank Mortgage successor, and it goes through the whole litany of what it deems to be its predecessors in interest. And as the court is aware, these mortgages get assigned time and time again over their life. And so I think if you track the deed of release on the Saguaro mortgage, it is really clear what it is, and it wasn't paid off until 2006 by virtue of the deed of release and reconveyance. And I don't know what else the appellant in this case could do but supply copies of his checks, copies of the stubs from Bank of America, copies of every single piece of paper that tracks these mortgages. There is actually no evidence, none, in this record that would suggest that every dime of that mortgage was not paid by the defendant in this case. And the plaintiff testified on page 66 of the transcript that when this property was bought at the trustee sale, it was subject to a mortgage. She just didn't say what that mortgage was. So I don't see there's an issue with respect to that, and it could not have been the defendant's sole obligation under any stretch of the facts or law.
All right. Thank you, counsel. Appreciate the arguments presented here this morning. We'll take this matter under advisement and issue our written decision in due course. With that, we are adjourned. Thank you.